Done speaking. Yeah, just a brief introduction. Thanks everyone for coming. Thanks Matt for your service again. Yeah, I've been on the board since last year, and something that definitely jazzes me up work-wise is to engage with people, and so we've got a bit of a goal to bring in more speakers, have more engagement, stimulate ideas, and pleased we've got three people that answered the call for this AGM. We've got Tom, John, and Dawn. We've got 60 minutes, and yeah, I put a question to these three, where impact assessment needs to go. And so we're going to get three different perspectives. All of them happen to have a connection to Simon Fraser University. I guess it just kind of worked out that way because I have a bit of a connection there. But so three perspectives on how to make things better in whatever way these people want to think about that. So we've got Dawn Hoogeveen. She's an adjunct professor in the School of Health Sciences at SFU in the Vancouver area. And she's also the director of Indigenous Center for Cumulative Impacts. We've got John Boron, who's an instructor in the School of Resource and Environmental Management at Simon Fraser and a PhD candidate there. And he does research on Indigenous self-determination in environmental governance. And we've got Tom Gunton, who's professor in the School of Resource and Environmental Management at SFU. So Tom's held all sorts of positions in government and in academia, and I will turn over to them in a moment. I guess the format will be, I think we've got Tom going first, and about 10 minutes each. And I think, yeah, let's keep it to 10 minutes each, and then we'll have plenty of time for discussion and questions. And I think Jeff I think he had said that if you put your hand up, he can enable audio if you'd like audio, or you can write a question in, I guess ideally it'd be one or the other, the chat or the Q&A. So we're not monitoring both. Perhaps we'll say the Q&A. Yeah, we'll wrap up before 1, and I'll leave it at that. If there aren't any other issues, Tom, I'll turn it to you, and I think we can. Tom, are you able to share your screen for your slides?
Yeah, thanks very much, Chris. And I'm just going to share the screen, and I'm speaking for the unceded territories of the Sankey and Esquimalt nations today. And thank you so much for inviting me and the rest of us. And we look forward to the conversation. As Chris said, we're going to be relatively brief. I've got a couple of slides just to help organize my thoughts. So I think you can see them now. Is that correct? Yes?
Yeah, we're good. Yeah.
Okay, perfect. So just 4 slides. And I just want to start off with talking about impact assessment and the great expectations we had going back to 1970 when NEPA was passed in the United States. Probably a number of you were not working in the field at that point. I was just starting out. So that was pretty exciting. And then we had ERP guidelines in Canada to guide the impact.
Hey, Tom, I'm just going to cut you off. It looks like your slide is, we're only seeing part of it. I don't know if you need to zoom out or something.
Okay, sorry. How's that?
Yeah, I can now see it. Yeah, I think, yeah, because someone else had comments on it as well.
Okay, sorry. Yeah.
Good.
Yeah, so the great expectations, the ERP guidelines, the passage of the legislations in the 1990s in most of the provinces of the federal government, and the various evolution of those over time, various iterations. So we had these great expectations of what impact assessment was actually going to do. We've had a number of reforms, just briefly adding cumulative effects becoming an essential part, regional assessments, strategic assessments, climate change integrated, now explicitly integrated into the legislation, sustainability introduced into the EA process, both legislatively and in practice, and Indigenous partnerships and Indigenous-led impact assessment, which I think John will certainly talk about today. And so we've had an evolution of reforms, and that's sort of where we are. The next way of looking at where we are is that we've done some survey research of practitioners and participants in the EA hearings, asking them how they think we're doing. So here is the level of agreement with some of the key criteria that you would use to evaluate an impact assessment process. Do we have adequate participation? 25% of the survey respondents say yes. Do we have clear decision-making criteria? Only 18% say yes. Impartiality of review panels, only 18% say yes. Adequate information, 16%. Sound methods of analysis, 13%. So there's very low level of agreement on the criteria that we would like these impact assessment processes to meet, which suggests we've got a bit of a way to go. And then other survey work that we've done is impact assessment. This is more looking at the methods and tools that we use. Is impact assessment prone to overestimating benefits? Yeah, 60% of people say yes, it is. Does impact assessment methods provide a comprehensive assessment of project impacts? Only 35% agree. Adequately consider impacts on Indigenous groups, 18%. Clearly communicate trade-offs, 15%. Really assess the public interest well, only 9% agree. So that suggests that we have these great expectations, and in terms of performance, we still have a bit of a gap here in terms of delivering on those expectations. And so we've done a lot of research, and I personally participated, and I know a number of people participating in this session have as well, in a number of impact assessment processes as a consultant, expert witness, et cetera. And so I just had a few thoughts to consider on where we go from here. Okay, and I won't spend a lot of time on these, but one that obviously we need to mention, particularly in this environment, is what we could generically call the efficiency of the process. There's a huge move afoot as we speak, particularly you see it in this election campaign about making EA more efficient to fast track projects, both by exempting projects and speeding up the process to under a year. And so we have to be cognizant of that if we're going to be successful in EA, is how do we design it to meet those expectations? In terms of moving, the second comment here is that we've got to move from these high expectations, or what I call utopian expectations here, to more realistic expectations of what EA is capable of delivering. We've added cumulative effects, which really gets into more comprehensive environmental planning onto the EA process. It doesn't do it very well. We've added climate change. We've added a whole bunch of different components to EA, and we'd be better off narrowing down and focusing on what EA does well and do that well, and leave some of these bigger questions to another forum where they're better dealt with through policy making, like climate change. Climate policy is done more generically. You can't solve climate problems within the perspective of one EA assessment. So let's move those big questions over to more generic policy, which then can apply back to EA in terms of regulations, et cetera, like we've done with LNG, requiring them to be net zero by 2030, and focus EA more on what it can do well. Because if we ask it to do too much, we're not going to do anything very well. Third point, I'd just say the importance of moving from an adversarial to a more collaborative process. Most EA processes, we have the project proponent on one side, and then we have interveners on the other side. And there's a adversarial quasi-judicial process back and forth, almost like court proceedings, which leads to, and I'll just the next 3 points sort of cover this, to second best outcomes when we have adversarial processes. And one of those is competing experts, and why we need to move from competing experts to joint fact finding. So if you take a look at EAs I've been involved in, one consultant's report for the proponent will say the risk of an oil spill is 16%. Other consultants work for interveners will say it's 45, 50%. A cost benefit analysis by the consultants will say there's a huge net benefit of 6 billion. Interveners would say, no, it's minus 15 billion. And that puts the decision makers and everybody else at a huge disadvantage because of this enormous gulf in information and evidence from different perspectives. And so instead of having competing experts, let's move to more of a collaborative joint fact-finding where we work collaboratively, interveners, project proponents, Indigenous communities, others, in jointly generating the information we need to make decisions, so that we can narrow those differences and at least understand why people may have different outcomes. But what we have right now is competing studies and just leaving everybody completely adrift. Specifically, we need better methods, and I'm just going to focus on economic impact assessment, which is a passion of Chris and mine. We've done a lot of work on this. Every EA has an impact assessment done that exaggerates the benefits of a project and underestimates the cost. And so if we look, for example, the Northern Gateway project, the consultants estimated 907, almost 1 million person years of employment from that project. When in fact, we look at the fine print, it was only 100 jobs. So that misrepresentation through economic impact assessment and exaggerating and misrepresenting benefits is something that's fairly easy to fix. And we advocate adding on benefit cost analysis, which is a well-proven technique to help identify more clearly what the net benefits of projects are and have a more realistic estimate of the benefits and the costs. And finally, there's the whole question of who makes the final decision. The last 20 years, I've been working in collaborative decision making, where we actually bring people together to try to negotiate and agree on a decision that is in everybody's interest, as opposed to competing experts putting all the evidence and relying on some expert, quotes, expert to make decisions. So moving to a more collaborative model, and we're beginning to do this with an Indigenous-led impact assessment to some degree, but we've got a long way to go. So, Chris, I think I'll just end it there. That's a quick overview of some of my thoughts, and then we can have more discussion of this later. Thank you very much.
Thanks, Tom. Yeah, we've got, there was one question put there, but maybe I'll save those to the end. And I guess, yeah, good. John, we'll invite you up next, and then we'll have Dawn after that. And John, you just got to put your mic on. I can see you.
Yeah, thank you.
Here we
Sorry,
go.
I'm just making sure that I'm sharing the right page here. Okay, I think you're able to see that.
Good. Yep.
Okay, awesome. So yeah, hi everyone. My name is John Boron. I'll go into a bit more of an introduction about myself. But I just wanted to let you know what I plan to talk about in answering this question that Chris posed to us. Where does EI need to impact assessment need to go? My mind turns to the stated goal of reconciliation and ongoing power and process issues related to the development and interpretation of various aspects of assessment and decision making. So today I want to speak on issues around legal pluralism, free, prior, and informed consent, and consensus building, and how the current process kind of we're not quite there yet, I think, is kind of my message. But also I wish to kind of promote the idea that we need a process that empowers communities to be involved in the assessment and decision-making process, as we see in Indigenous-led assessments. So just an introduction about myself. I'm a mixed Haudenosaunee, Gayagohono, Cayuga, Wolf Clan from Six Nations of the Grand River. I moved to Coast Salish lands, Musqueam, Squamish, and Tsleil-Waututh lands, where I currently reside, back in 2015 to do my master's in resource environmental management. And somehow Tom and Sean Markey, my current supervisor, convinced me to stay and do a PhD, which I'm working on now. And I'm currently also an instructor teaching impact assessment and Indigenous planning in REM. My research area is focused on reconciliation and pathways to self-determination in resource management. Looking particularly, some of my work is looking at UNDRIP implementation and in our resource management institutions. And so with asking this question, where does impact assessment need to go? I thought about reconciliation and how we need to kind of rethink the way we approach reconciliation. And so this is the BC Environmental Assessment Act, Section 2. The purposes of the BC EAO are to support reconciliation with Indigenous peoples by supporting the implementation of UNDRIP, recognizing the inherent jurisdiction of Indigenous nations and their right to participate in decision-making in matters that would affect their rights through representatives chosen by themselves, and collaborating with Indigenous nations in relation to reviewable projects consistent with UNDRIP, as well as acknowledging Indigenous peoples' rights recognized and affirmed by Section 35 of the Constitution in the course of assessments and decision-making under the BCEAA. So obviously here, the United Nations Declaration of Rights of Indigenous Peoples is highlighted twice. I'd say Article B and D here also really promote the employ of UNDRIP in working towards achieving that stated goal of reconciliation through impact assessment. And so I just wanted to bring up a couple. So in my work, I'm working on developing an UNDRIP compliance framework centered around the petroleum natural gas industry. And in that compliance, I'd argue that obviously every article of UNDRIP is particularly relevant to resource and environmental management issues. But I wanted to pull out a few here to think about. Article 18, Indigenous peoples have the right to participate in decision-making in matters that would affect their rights through representatives chosen by themselves in accordance with their own procedures. Article 19, states shall consult and cooperate in good faith with Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them, including permitting, and approval of EA certification. Article 32, Indigenous peoples have the right to determine and develop priorities and strategies for the development of or use of their lands or territories and other resources. And states shall consult and cooperate in good faith with Indigenous peoples concerned through their own representative institutions in order to obtain their free and informed consent prior to the approval of any project. And so obviously this act enacted in 2018, but came into effect in 2019. But my work looks at the oil and gas industry, and I'm often thinking about the Coastal GasLink pipeline project and how it's worked. As an example, we can see how the previous Environmental Assessment Act is implicated in a system that legalizes the forced removal of Wet'suwet'en land defenders from their territories. So Article 10, Indigenous peoples shall not be forcibly removed from their lands and territories. During the consultation for the Coastal GasLink project, specifically the Dark House Wet'suwet'en hereditary governing house group wasn't consulted during the environmental assessment process. Many of these members, or I should say, the leadership of this group were a part of the land defenders trying to protect their territory, and so the BC EAO approved their certificate, the Coastal GasLink certificate, despite this lack of consultation of this specific group. Although they consulted with Wet'suwet'en Band Council governance. But we see how this EA certificate was utilized by the proponent to go to the courts and get an injunction, and then that injunction was used by the RCMP to forcibly remove Wet'suwet'en land defenders. Under the new act, the first EA certificate granted under the new legislation was the Caribou Gold mine, where there are 3 First Nations participating. with the Zatzal First Nation not providing their consent, citing concerns of cumulative impacts. And obviously, Zatzal First Nation lands and waters were significantly impacted by Mount Poly tailings dam failure. And so they have significant concerns around more development, especially mining development in their territory. The BC Environmental Assessment Office granted the environmental assessment certificate in 2023, despite lack of Zatzal First Nation consent. I believe they're currently engaged in dispute resolution, working to resolve their concerns. But as of 2024, some news releases stated that Zatzal First Nation were looking into their legal options to go after the BC EAO for providing this this certificate. And here I just want to say this is under the new process that centers consent seeking, and I just want to mention that consent seeking is not consensus building. It still promotes this, as Tom was talking about, adversarial approach to decision making. I'm kind of running overtime here, but I wanted to provide this other example. Tahltan central government in 2022 and 2023, the BC and Tahltan central government signed consent agreements in accordance with Section 7 of DRIPA surrounding the Eskay Creek mine and the Red Chris mine as well. This agreement requires the BCAO to obtain consent from the Tahltan central government before accepting any proposed amendment to the EA certificate. And as you'll know, because of the tariffs, we heard from Premier Eby on February 3rd, a planned announcement to fast track 18 natural resource projects, including both the Eskay Creek and Red Chris mines. This approval or this stated political goal was done without the consultation of the Tahltan First Nation. So you see kind of this lack of respect here in not consulting them even before making this announcement. And then just reflecting on the pathway forward, I want to talk about this issue around sovereignty and interpretation of sovereignty. And so I think the fundamental issue is around the state's thoughts about maintaining exclusive sovereignty, where their sovereignty is exclusive and supreme source of political authority. And I want to, in thinking about where we need to go, I want to promote this idea of relational sovereignty put forward by Matthew Wildcat, who's a Nehiyah scholar from Maskwacis in Alberta. And so relational sovereignty is the ability to create structures of government that are reflective of relational philosophies, talking about how different sites of authority can establish relationships of shared authority over areas of shared concern. In the Delgamuukw decision, Chief Justice Lamer talks about how rights that are recognized and are affirmed are not absolute. I tend to agree with this as I teach students about relational sovereignty, but I argue that, well, rights that are recognized and affirmed are not absolute. That should apply to the state as well. And so I have this image of the Tura Wampum, which is a treaty agreement between my ancestors and Dutch settlers that really shows how our relationship can move forward in terms of having different sites of authority, Indigenous governments and settler governments, establishing relationships of shared authority over areas of shared concern, that being the river of life that we both travel down. I'm running out of time. In March, the federal court provided some more information around how they are seeking to interpret free, prior, and informed consent. And they mentioned how FPIC is not a right to a veto, but it is a right to a robust process. It requires more than what we've been required under common law, geared toward a mutually acceptable arrangement. And so we see how the state or the courts are trying to push us towards this relational mutual agreement. And so just some additional thoughts on what this robust process should look like. Echoing some of Tom's thoughts, proactive planning and decision-making frameworks that empower community-based decision-making, It should be a process that builds consensus rather than an adversarial and hierarchical approach to impact assessment and decision making, centering shared interests and shared concerns and addressing them through joint fact finding, as well as a process that recognizes and respects Indigenous rights, governance laws, and jurisdiction, respecting the reciprocal responsibilities Indigenous people have to their territories. That's all I've got. Well, I think I should stop it there, but yeah.
Yeah,
thank
no,
you.
that's great, John. I mean, I've got a question that I can fire at both you and Tom, but let's hear from Dawn, and then maybe the three of you have some thoughts to share with one another. But let's turn it over to Dawn. Thanks, John. Dawn, are you there?
Yes, I'm here.
Okay, we'll leave it to you.
Thank you. Allow Zoom. Okay. Uh-oh, I have a new laptop and I have to allow Zoom to share my screen. Uh-oh, and I have to get a password for that. Uh-oh. Well, I might just not share my screen then. I have a really beautiful PowerPoint, but oh shoot. Is everyone there still? Am I here? Are you there? Okay.
We're here.
Okay.
If you wanted to, or could, email it quickly to Chris or I, we
No,
could
it's
share
okay.
screen for you. But
we do so much PowerPoint. I'll just read my slides. So I've got to say thank you, John and Tom, for your wonderful presentations, and thanks, Chris, for the invitation. I'm actually calling in today from Mi'kmaq territory, from Millbrook First Nation, though I normally reside on the Musqueam, Squamish, and Tsleil-Waututh territories. And along with thanking my co-panelists, I just wanted to, I've been on the executive for the IAIA, this group here out west, not on Mi'kmaq territory, where I'm just visiting today, but for 2 years. And so I've really seen all of the work that, and the leadership that Matt has brought. I think Matt, is it right that Matt's been president for 6 years? Is that correct? Yeah, so I just wanted to really, acknowledge the 6 years of leadership that Matt's brought to the board, and as well as Randy's, just always been in my 2-year term as on the executive. Randy's been an excellent treasurer, and Claire's been really, really helpful, showing up and taking notes. So just wanted to begin by acknowledging all of the work in the background that has, including leading up to today's AGM. I was able to discuss with some colleagues here in Millbrook, near Truro, Nova Scotia, over the last couple of days. I was like, oh, I'm giving this little conversation around the future of impact assessment. So I want to also thank Chris for the question, because it's led to some really, really interesting discussion. So I guess, there's a lot of critiques of impact assessment that communities face the greatest impacts, and are concentrated, and the impacts are concentrated on certain populations like Indigenous communities, and that it really impacts Indigenous health in terms of resource development. So examples of how, people that end up sitting at the table and in the decision-making seats and looking at the racialized and gendered dimensions of the way that decisions come to be made. But also, I want to acknowledge that there's Indigenous governments that are increasingly proponents or holding their own processes, Indigenous-led processes. And John didn't have quite enough time to cover the SSN process that he had a slide on, but I think that that's, really a really excellent example of an Indigenous-led impact assessment in terms of the nation taking their own decision-making authority into their own hands, and really creating a system run by local families. And Northern Health has done a good amount of work on documenting the impacts of resource development on community in terms of the healthcare system as well. And so, as we know, in terms of impact assessment, and that the many issues that it gets tasked to adjudicate when looking at project proposals, it includes, the influx of funds from employment, as well as, the benefits on local economies, but some of the social impacts, like the increase of drugs and alcohol and shift work that can leave, uneven impacts on community that are often classed, gendered, and racialized. So there's this overall narrative, right, around, that is well documented and evidenced around a disproportionate burden and lack of funding and resources that's placed on communities that have to be participate in impact assessment. So, you know, I really liked Tom's comments just around looking at methods for jointly governing knowledge systems that create more proportionate, more representational and collaborative impact assessment processes through, you know, Indigenous-led impact assessment, as well as other unique processes that bring everyone to the table, so that there are more unequitable or more equitable outcomes on adjudication processes for community. So yeah, I know Jess and Rosemary are giving a talk at the end of June, and with Jess, as well as some other colleagues at UBC, we did a project just identifying the omission of gender in impact assessment processes. And we looked at 37 impact assessments, like the EAs that were certificate granted between 1995 and 2019. And we found that 60% of the projects didn't consider gender at all. And when the remaining 40, it was a little bit of a like kind of gloss over in terms if gender was taken into account. It was like kind of, I don't know if you'd call it gender-based analysis, super light, but it just seemed like, you know, maybe a checkbox approach, but not even. It was really collapsed into concerns around women's issues and really obscured some of those intersectional impacts and downplayed, you know, violence along both racialized and gender diverse lines. So that paper kind of in the Canadian Geographer outlines some of the evidence around how racialized and gendered impact assessment processes can be. And I was also just going to reference another piece of work that I have been a part of with Anna Johnston and Heidi Walker, which is a gender-based analysis plus respectful engagement for equitable outcomes document that we released in 2024 with West Coast Environmental Law. And it outlines some of the concerns that I think are you know, also well documented around uneven impact assessment processes, as well as you know, outlines arguments that I think align with some of the work that John Sinclair and Meinhard Dole and others have done around next generation impact assessment. And you know, EA or IA is not, it's as, you know, dovetailing and echoing what where Tom began. I think I agree, it's not a solution or remedy for all the social and environmental and economic impacts of cumulative effect, including cumulative effects of resource development. Like, we can't look at everything through impact assessment. But I do think that now is a really important time for impact assessment, including for looking at improving the way that we do Indigenous cumulative effects assessment and governance, and that the processes in British Columbia and in Canada really have increasingly aimed to meaningfully engage and consider holistic understandings of health and community well-being. And I'm thinking of, you know, some of the work that the BC EAO has done around arguing for earlier engagement or outlining early engagement, attempting to outline early engagement, or what John Sinclair often refers to as like early and often engagement and participation processes, and just continuing to make steps forward in accounting for these axes of difference that I think, you know, federally the agency's GBA plus guidance document is a good step in that direction, and continuing to foreground the rights of Indigenous peoples and rights and title and reconciliation. And I totally agree with John, we still have a long way to go there. And I can't help, I know that the 5-year review of the EA Act in BC has been triggered, and I was just thinking back to the 2018 EAO revitalization report lately, and just revisiting that, and that we don't need to reinvent the wheel here in terms of all the work that's gone into thinking about revitalizing EA. So I think there's a lot of good governance ideas out there, and just we're still really struggling with implementation. So where does IA need to go from here? Asks Christopher Joseph. Well, I would say that Section 22 and the IA factors, including looking at cumulative effects and looking at examinations of sex, gender, and other identity factors, are really important. And I think that, you know, at the IAIA last year, Canadians made up 25% of the population. And I think that Canada is in a really strong place to continue to lean into the international good governance standards space. And it's actually important that we do that. And I think that, you know, highlighting John's presentation as well, that we need to continue on our journey to meaningfully implement the United Nations Declaration of the Rights of Indigenous Peoples, including the Act, the DRIPA Act, the Declaration of Rights of Indigenous Peoples Act in BC, and work on our different supports for Indigenous-led impact assessment, which I think has come to mean a variety of things over the last 5 years. And one of the things that I've seen, which is a comment, is just the way that Indigenous governing bodies and that interpretation and definition, and this would be a question actually as well, like a discussion question, but my sense is that the interpretation of Indigenous governing bodies the legal interpretation has actually opened up in the last 5 years. So yeah, I would just argue that IA needs to continue to work from a holistic cumulative effects assessment lens to produce more equitable outcomes and bring everyone to the table for those methods that Tom referenced. And in closing, in Bologna, Trish Fitzpatrick and I are organizing a session that's called Self-Determination and Culturally Relevant GBA Plus, an intersectional impact assessment, an invitation for action. It's always shorter when you write it and then you read it and you're like, that's so long. Anyway, it's a discussion that I'd welcome anyone who's in Bologna to attend. It's on May 2nd at 4 o'clock. And we're gonna actually just host a bit of an informal workshop and look at questions for practitioners around lessons learned and experiences and barriers, as well as best practices and resources for really broadening support. So yeah, if you're in Bologna, I hope to see you there. And thanks, Chris, for the invitation and to my co-panelists.
Thanks, Dawn. Yeah, and thanks all three of you again. So, you know, I could pose a question at all three of you. You may have thoughts to pose to each other. And there's one question from Claire I see in the Q&A. Do you three have any burning things you want to pose at one another? Or should we cover off Claire's question and then I can pose a question for all three of you? All right, sounds like that's where we're going. So Claire asked, she asked Tom, but maybe it's related to all of you. We have expectations for increased speed and efficiency. How does that relate to efficacy? And do you think under a year is really sufficient for a proper EA?
Well, I mean, there's no real answer to that question because it's a very challenging question. But you can certainly, if you do preparatory work and you have joint fact finding and you have engaged fully with the Indigenous community beforehand, and Indigenous communities and others have developed their own environmental plans or community plans so they know where they want to go. Don't leave all of that on the desk of EA to have to do all those cumulative effects and everything else. Those should be done as part of another planning process way in advance of projects being proposed. And if you do that, then it becomes relatively a lot more straightforward to assess what the impacts of a project will be relative to what the community aspirations are and where communities want to end up. So if you do that kind of preparatory work and take a lot of the weight off the shoulders of EA and accomplish those tasks elsewhere and beforehand, yes, you can speed up EA. But I was just making the main point, though, that if we are not cognizant of the pressures that are being pushed on the impact assessment process over the next year or two and right now to speed it up and expedite it, EA is going to be significantly weakened. So we see exemptions, we're going to see changes in legislation, expedited processes through exemptions, et cetera. The pressure in this environment is so strong to expedite that we've got to come up with a very creative and effective way to meet some of those expectations while still doing good, sound EA work, and it's not going to be easy.
Tom, John, or Dawn, did you want to add to Tom's comments? Okay.
Yeah, sorry, I have a couple thoughts. Just agreeing with Tom and thinking about how often, especially some Indigenous-led assessments, are geared towards specific projects, and a lot of time, money, and resources are spent on developing that assessment process that is project focused. And a lot of the time, especially in Treaty 8 territory, we're looking at cumulative effects. A lot of the time, land use data is only known about or collected when project proposals require traditional use studies. And so that if all of that information was, pre-collected, and we had actual land use plans developed and nation plans developed around their interests and aspirations for their lands and territories, then that information can feed into the impact assessment process a lot easier and increase the timelines of impact assessment being done for a specific project.
Thanks, John. Don, unless you want to add something, I will, we've got three academics up here talking about what should be. It's often an angle I come from as well. But I think most of the people on this call are practitioners. And so maybe I'll put a question to the three panelists, but also all the practitioners. I know one in particular on the call that I saw earlier, thinks a lot about that, what Tom talked about, the utopia versus what's realistic. And as Tom made clear, right now there's so much pressure to just get things, going. And so, to all of you, what's realistic right now? And yeah, really encourage practitioners on the line. I'm not sure what Jeff had set up, whether people can actually share their audio if they want to ask that or type it in. But, all of you, all panels and practitioners, what is possible right now to move things in the right direction? And I'm hoping someone can chirp up and raise your hand. I can enable audio. Yeah, so that's what Jeff's saying. Can someone offer, and maybe I'll turn to a panelist if they can, speak to what's realistic right now. Okay, we got Martin.
Hi, my name's Martin from Yukon, and I've been in the EA business since 2000, and a lot has changed and a lot has stayed the same. But one thing that's been constant is, more and more things are happening in EA that, and I think Tom pointed that out, maybe better at home somewhere else. I think, an assessment that I would have done 20 years ago, 25 years ago, and an assessment I would do of the same project today, fulfilling all the requirements, it would be 5 times, the work or more. And I personally believe that a good, one of the reasons for that happening is because of all of the things where we could be addressing issues. The EA process is the one that's transparent and public, and everybody can have their say and ask for things. But do we just need to include all those things, or are there better places? And one of the things, listening to the presentations today, is I'm getting a little bit of whiplash in a way that here's things that we shouldn't be doing in EA, and then there's more things we should be addressing in EA. and Jonathan, I do not disagree with one thing you said, other than maybe EA is not the place to do some of them, or maybe even all of them, right? And I don't know. I'm not answering the question. I'm just basically saying, expressing my frustration in that everybody is piling everything on the EA process, and then they say, okay, now that we tripled your workload, you got to do it in half the time. And at some point, as practitioners, we need to say, or maybe it's not so much the EA practitioners, it's the people who, design the processes, who say, hey, we need to have a frank discussion on, let's not talk about EA versus permitting versus whatever. Let's see, here's a project idea, here's a constructed thing. What does that thing has to fulfill, and what criteria does it have to meet along the way? And then we decide where do those things go? And I don't know, who would have the power to actually convene such a committee, conference, whatever you want to call it. But I think it's really at the time where we need to stop talking about EA versus permitting versus planning, in the sense that right now we're doing a lot of land use planning in EA. Like I would say 60% of the issues I deal with on a daily basis are not questions about this project. They're questions about the type of project. Anyways, I'm taking up a lot of time, but so I don't know what's realistic, but I think there is an immense need. And in some ways, now might be the time because the pressure is here. And so maybe things might actually be moving. Thank you.
Thanks, Martin. Panelists, anyone want to respond to that? Okay.
I would just, Tom, you go ahead, but I'll just quickly say, I feel like this is like where it's like cue the failed BC land use planning process from the 90s is usually where this is usually what I end up hearing, is that there was this great robust land use planning process that really didn't get off the ground. So, but over to you, Tom.
Well, yeah, I think no,
Words to Tom.
I agree completely with Martin's comments, and it is just so important to have a realistic assessment of what EA can do and narrow that perspective. Don't keep adding stuff onto it and then narrowing the time and money for it. All of these other processes and very important questions that Jonathan and Dawn raised that have to be addressed are better addressed as part of another planning process that is pre an impact assessment. And I just think of the example, and Chris is quite familiar with this, the work we've been doing with the Metlakatla First Nation over the last 10 years, where they were initially responding on a project by project basis to do a massive assessment of the impacts of these projects on their communities. They switched to doing a planning process, coming up with what they call it cumulative effects planning, but it's really a planning process where they set out aspirations for the communities, thresholds for the community, and came up with a plan for the community and addressed many of these very important questions in that planning process. So those questions were addressed and answered before a project came along and was proposed. And that made the project impact assessment much more effective and much shorter because and narrower, because it delegated a lot of these big challenges and tasks to another process that was better suited for them. And I think that's the direction where we really need to go.
Thanks, Tom. Kate, you asked a question. You put it in the Q&A. Did you want to read it out, Kate, or should I read it? Not hearing you. So she wrote, a perpetual issue we hear in my jurisdiction. So she's up in Mackenzie Valley area, Northwest Territories, which is linked with the importance of having community plans, monitoring programs that can facilitate efficient EA, is the lack of long-term stable funding for Indigenous communities and governments to do this work. When there's only money available to do this work in the context of project assessment, it's hard to make progress. So I think it amounts to a matter of making changes outside the EA process that would help us do EA better.
Yeah, I feel like this is just kind of an additional dimension to the comments that we just heard from Tom and Martin. Similar thing. It's hard to do that stuff in EA because it takes time and money, and neither of those things are present in EA in great amounts usually. So it's tough.
Thanks, Kate. If there's no comments on that, Scott, you had your hand up. You still have a question, Scott?
I'm good, Chris. I think Martin covered a lot of what I would have said. Thank you.
Oh, come on. We've got 12 minutes still.
I could talk for 4 hours on it, so you don't want that either. So we'll leave it as it is.
Did anyone else have any questions, or panelists, any thoughts you want to bounce off each other? Again, I could bring you back to, what's realistic right now in this political climate to, on the one hand, address all these needs like Indigenous reconciliation, gender-based analysis, sustainability, whatever climate, and yet people just want stuff moving.
Well, just maybe a quick comment again on one dimension of this, which the concept of joint fact-finding or collaboratively getting information. I mean, every EA process I have been in, the proponent has done a whole bunch of studies, and then interveners go out and do their studies, and then the interveners cross-examine and try to correct the proponent's studies and vice versa, and then there are more studies done. It is an incredibly inefficient process to have all of these different experts developing their own independent studies. And so there's a huge opportunity to engage and organize joint fact-finding, and that can be done in several different ways. I mean, one very easy way of doing it is to have the agency itself take on the responsibility under the direction of a collaborative group of stakeholders in Indigenous communities to actually undertake the impact assessment on its own. This is done in the US a lot. The quality of the work is a lot better than relying on a proponent with bias to do the work and then having interveners do their own separate work and trying to bring all of that together. So there's a huge opportunity to significantly improve both the quality of information and the efficiency of collecting information by collaboratively developing that through some kind of joint fact-finding process.
Hey, George Hegman, are you still on the call? Because you're someone that's extremely experienced, been a practitioner for so many years. You know, what's possible, George? Are you on the call, George? I'm putting you on the spot. I'm scrolling through to see if George is there. Oh, I think he's gone.
No, he's here, Chris. He's here.
Oh,
Yeah.
James Hoffoyle's question in the Q&A section.
yeah, maybe George
makes me laugh.
All right, James has got a question.
Yeah.
Curious on panel's thoughts on political rights use of the term economic reconciliation.
Yeah, that's something I could talk about probably, for hours and hours. It's the basis of a large portion of my PhD. And we're seeing it come up, especially around the conversation around the Prince Rupert transmission line, well, the minister's deciding now whether or not it's going to reach a substantial start. But you have an Indigenous proponent that is arguing for this, or is a proponent, obviously, of this pipeline, claiming that economic reconciliation should be tied to this. And then you have the competing interests of the Gittinyao, who are vehemently opposed to the development of this pipeline. And the minister needs to balance these competing interests around the concept of reconciliation. And so I'm really interested in seeing what happens. And again, this is not, impact assessment is not the forum or tool to be deciding, the political aspirations of two neighboring First Nations, right? As a Haudenosaunee person, like, we know we're not supposed to be involved in other people's governing systems, and what is the role of the BC government in determining that relationship? And so, but getting back to the economic reconciliation, yeah, it's frustrating because we're dealing with a long history of ongoing settler colonial impacts, where communities need economic development, especially short-term economic development benefits coming from a lot of these projects to help with a lot of their socioeconomic issues within their communities. And so that's the challenge, is thinking through what is right for the community, and if and the challenge that communities have to come and decide, right, is this project, are we able to accept the impacts, the social impacts and environmental impacts for the economic benefits. It's really frustrating because for me, when I think about reconciliation, it's not only reconciliation among you know, the settler state and Indigenous peoples. It's a reconciliation of our relationship to the earth, right? And you know, resource extraction that you know, flies in the face of that, and it isn't really, in my mind, true reconciliation or meaningful reconciliation. Yeah, that's what I've got so
Thanks,
far that I'm
John.
thinking about. Yeah.
Don or Tom, if you want to add to that?
Well, I was just, I mean, I think reflecting on, this isn't necessarily directly related to economic reconciliation, but, you know, I really appreciated John's comment around relational authority. And I think that, you know, if we're trying to make impact assessment more efficient, right, there's a big focus on efficiency. What's inefficient is litigation. So I think that there's just in terms of that methods for jointly generating knowledge in impact assessment, you know, the reality is that not all communities and regions have had the same support that Metlakatla has had. I think that you know, it's really interesting to see the joint terms of reference for the Ring of Fire that the agency rewrote, right? Like went back to the drawing board on. And so I think that, you know, there's new models that are, and so whether or not you'd call that terms of reference process inside or outside the IA process, I guess is a different question. And that, but I guess the overarching challenge that we're left with is how to improve regional planning processes outside of IA. And that's like there's no answer to that, which is why things get folded into IA. So just yeah, I think the relational authority, or just like thinking with the wood fiber process that probably people on the call know more about than I did, but my understanding was that basically like the Squamish Nation did the information requests themselves and got support through the BCEAO. And so I think that there are these novel new ways of doing IA that are more collaborative and avoiding litigation, and some of our Northwestern examples aren't practicing that, what we've seen in other better cases. So
Thanks, Don, John, Tom. Yeah, really appreciate you finding the time to put in some prep for this and to give the talk today. Before I turn it over to Jeff, who's the new president, yeah, I just wanted to say for folks on the call, you know, if there are talks or events or types of engagement that you would like, you know, we'd like to hear it on the board so we can try and set these types of things up.